Empezamos con Gregor Puppinck, director de European Center of Law and Justice, y nos va a hacer una ponencia cuyo título ¿Is there a right to abortion? Gracias, Gregor.
Muchas gracias, Algarita. Thank you very much for the invitation. I would like to discuss the issue of a right to abortion. Can we say that there is a right to abortion in international law, European law, and constitutional law? The right to abortion is based on lies. First, there is a lie that abortion is a liberal practice, that it is intended to liberate women, when the aim of its historical advocates was, above all, to increase their control over human reproduction and life. Then there are the lies that abortion is safe, that it is health care, that its legalization would reduce maternal mortality, or that women would be victims of forced pregnancies, as if pregnancy were fatality. There is also the lie that it would be impossible to prevent or reduce recourse to abortion, or that abortion would be a prerequisite for equality between men and women. So many lies. However, the biggest lie about abortion is the denial of the existence of the aborted child. It is on that lie that the so-called right to abortion is based. It is the ignorance of the child that allows abortion to be presented as a woman's right over her own body. That is what the Supreme Court did in Roe versus Wade in 1973, and it was wrong. This is a gross lie because abortion is obviously performed on a child. It is the child who directly suffers the abortion, not the mother. It is the child who is aborted, not the mother. This lie goes even further, since abortion advocates are always careful to avoid talking openly about abortion itself. They use periphrases such as procedure, menstrual regulation, reproductive rights, or women's right in order to avoid saying abortion. They do not assume the bloody reality of what they are promoting. This lie spreads from the international abortion lobbies and the United Nations. It is a prerequisite for a right to abortion. This lie was the basis of Roe versus Wade, and it was this lie that the Supreme Court finally rejected in Dobbs. Admittedly, the latter followed the example of the European Court of Human Rights, which had already stated that pregnancy and abortion are not only a matter for the mother's private life, but also for the unborn child she is carrying, as well as for the child's potential father and society. It is because the child exists, even if he is only described as a potential human being, that pregnancy and abortion go beyond the private life of the mother. Moreover, in several important cases, the European Court of Human Rights has applied the European Convention to the child from before birth in relation to the right to life, respect for privacy, and even the prohibition of torture. The Court of Strasbourg has ruled that the protection afforded by the state to the fetus is justified in view of, I quote, right and freedom of others. As Judge Pinto de Albuquerque rightly pointed out, this means, I quote, that the embryo is another, a subject with a legal status. This is the key reason why abortion can never be a subjective right, because no one can have an arbitrary right over the existence of others. This is also what the Supreme Court says. I quote, abortion is different from other rights because it destroys what Roe called a potential life and what Mississippi law calls an unborn human being. This means, as the European Court has repeatedly made clear, that the right to respect for private life, I quote, cannot be interpreted as conferring a right to abortion. Moreover, during its case law, the European Court made clear that the Convention does not guarantee any right to undergo an abortion or to perform it, or even to assist in its performance abroad with impunity. The Court of Strasbourg has also ruled that the prohibition of abortion does not, in itself, violate the European Convention. Thus, there is no right to abortion under the European Convention, nor under the US Constitution. There is no doubt. Moreover, the numerous commitments made by states to reduce and prevent recourse to abortion prove that abortion is not a right. Because if it really were a fundamental right, it would be absurd and unfair to prevent its use. Disguising abortion as a right does not change the nature of the act. It must be understood that human rights are not created by judges and parliaments, they pre-exist. People proclaim, declare, and recognize them, but they do not create them. What is a human right? It is a guarantee offered by the state to each person to respect his or her ability to fulfill the potentialities of human nature, to think, to learn, to express oneself, to pray, to associate, to found a family. Human rights do not guarantee just anything, but they protect the exercise of the human faculties by which we fulfill ourselves as human beings. Human rights are derived from and protect human nature. However, can a woman be said to be fulfilling and humanizing herself by aborting the child she is carrying? Certainly not. The suffering caused by abortion is there to prove it. If abortion were a right, it would respect human nature and not cause suffering. Between a fundamental right and abortion, the difference in nature is obvious. Abortion can never be a fundamental right because its primary, direct object is evil. It is a destruction of innocent human life, whatever the intention or reasons for that destruction. There is no point in crying that abortion is a right to make it a right, or even to enshrine it in the Constitution or in the EU Charter of Fundamental Rights. It does not change the reality of the act. So yes, there is no right to abortion under the European Convention as the US Constitution, nor under any other human rights declaration. But there is a right to life that sometimes is said to start from conception, like in the American Convention on Human Rights adopted in 1969, which states that every person has the right to have his life respected. This right shall be protected by law and in general from the moment of conception. In this regard, the European Court of Human Rights recognized that it is, I quote, legitimate for a state to choose to consider the unborn to be such a person and to aim to protect his life. Like the US Supreme Court, the European Court leaves states free to determine the starting point of the right to life and therefore to allow abortion or not. This is already a concession made by the judge to legally tolerate abortion, and it is based on another lie, namely the false distinction between the reality of the unborn child and the legal notion of person. In order to allow abortion, the European Court declared itself unable to know whether the unborn child is a person, even though it does recognize that the unborn child belongs to the human species. It is this lie that allows judges to turn a blind eye to abortion and to let each state decide on the matter. Now, the situation is pretty much the same in the US, where each state can regulate or prohibit abortion. This is clearly an improvement compared to the previous situation, but it is not enough because the Supreme Court does not yet grant legal protection to the human beings before birth. Such protection is needed, for example, to prohibit late-term abortion, which the Supreme Court itself calls a barbaric practice, as well as abortions based on the child's sex, race, or disability. There is still a long way to go before Western society becomes aware of the value of every human life again, even of the weakest. But I am confident because more and more physicians and midwives are refusing to perform abortion. It is becoming increasingly clear that sucking up and grinding a fetus, crushing its skull, and dismembering him to extract him, or injecting poison into his heart is a crime. This is the bloody reality of abortion. It is because abortion is a crime that its advocates have been in a moral panic since the Supreme Court ruling. Because this crime came to light, it is no longer hidden behind the so-called constitutional right to abortion, which offered them a fake moral guarantee. They are stricken by panic, even in Europe, in this parliament, even so they have a large majority. Their panic reveals their own weakness, their moral insecurity. They have no argument other than invective and the apologia of abortion. They can pass repeated resolutions, as they do. They can affirm and enshrine abortion as the supreme European right. They can exclude us from this parliament, as they are willing to do. They can censor the defenders of human life, as they do. All this will not change the reality. Abortion will remain a crime, a taboo dogma that rests on the sand of lies, and that will eventually collapse. For in every new generation that God creates, the pure consciences of young people revolt against this crime that cries out to heaven for justice. I thank you.